Today's You Ask, I Answer may be longer than normal because a whole bunch of people everywhere just started getting notices from companies like Google saying, here's what we're doing for GDPR compliance and what you must do in our software. And of course, for folks who have not been following along closely, there's a lot of questions like, what is this GDPR thing? So today, we're going to do the GDPR for the average marketer and what you need to do. Full disclosure, I am not a lawyer. I am not a compliance expert. These are not, if you have legal questions, please contact a real lawyer who deals with compliance, data governance, etc., things like that. If you have any shadow of a doubt about potential legal issues within your company, please contact a qualified legal professional. So, GDPR, what is this thing? Well, it is probably the biggest privacy change in the last 20 years in terms of what marketing can and can't do. GDPR stands for the General Data Protection Regulation. It is a law that the EU established in 2016. It's been on the books for that long. The reason why you haven't heard of it is that they gave the planet 2 years to comply with it. Now, the intent of GDPR is to strengthen data protection, strengthen privacy laws for people in the European Economic Area, the EU, and promote the lawful free flow of information across borders. Here's what's different about GDPR. Here's what's important about it. GDPR applies to all people within the physical borders of the European Union. They're called data subjects. And it treats their data, their personal information, as private property owned by the individual, just like their car or their house, and expect companies to treat that data with the same safeguards that they treat their own data. Now, that's a really important distinction because it's not EU citizens. It's not EU people only, citizens of member states. It is any person within the physical boundaries of the EU. If you are a BU student and you go to Paris for a semester abroad, your personal data while you are physically in the city of Paris is governed by GDPR. Now, what's involved? There's 5 major things inside of GDPR that are important. There's the right to access. Any EU data subject, meaning person in the physical borders of the European Union, may request their right to be forgotten by any entity. So, if you are in Paris, and you can contact Google and say, I request that you delete all knowledge of me. I have the right to be forgotten. There's the right to access. EU data subjects can request any and all data the company has about them free of charge. So, again, if you're in Paris, you can talk to Facebook and say, give me all of my personal information. 100% of what you know about me, give it to me. And it's at your expense, not mine. As you can imagine, financial services is a little unhappy with that particular piece. Privacy by design is the third thing. Rather than be an add-on, companies are expected to design their systems for privacy from the ground up. This means that instead of collecting and encrypting data, companies should be collecting less data and obviously encrypting it strongly. And the expectation of privacy is on the company to provide. So it is not on the citizen to have to judge whether or not they feel the information is going to be safe or not. By law, if you are an EU data subject, the companies you do business with must provide privacy from the ground up. The fourth is data portability. EU data subjects have the right to request data about themselves in a common machine-readable format and be able to give that data to a different company if they so choose. So, if I am in Bucharest, I can go to Google and say, I want all of my data in a machine-readable format, and I want you to transmit it to Bing, because I want to use Bing as my primary search source now. And so, and Google, if you are within the European Economic Area, must comply with that request. And finally, strengthen consent. And this is the one where marketers are going to get bitten the hardest. Companies that do business within the EU or with EU data subjects will be required to simplify consent requests. This means that You know, the 75-page terms of service that you get when you sign up for a social network or install a piece of office software? No more. It now has to be easy enough for the average citizen to be able to understand and agree to. Some people are saying 1 or 2 pages or less. So no more pages of unintelligible user licenses, no more tricks designed to mislead consumers, no more pre-checked boxes. All that stuff has to go away. And you have to be able at any point to prove the consent that you've received. So for people who are buying lists or using third-party data and advertising systems, not going to fly anymore. That is now all stuff that is not permitted under GDPR. So again, if you're doing business with people who are within the borders of the EU, all these things have to change. Now, let's talk about the companies that are impacted. GDPR impacts anyone who does business with an EU data subject, regardless of citizenship. So if an American is in Paris, GDPR applies to that American while they're physically on EU soil. That also means that if an EU citizen, for example, like a French citizen, comes to Boston and has a beer and leaves their mailing address and goes back home to France and criticizes American beer, when they get an email from that company, from that bar, saying, oh, thanks for whatever, now that citizen's data is governed by GDPR. So they, and any future interactions are governed by GDPR for, as long as that person is on EU soil. So things like, for example, if you are collecting any kind of web data, so name, email, IP address, stuff like that, or you use software that collects it, GDPR probably applies to you regardless of your location on the planet, because you almost certainly get some web traffic from European Union member states. If you go into your Google Analytics, look at how much traffic you get from Europe, from the EU. If you get 0, and you've gotten 0 for the last 2 years, then you're probably fine. But that's probably, I can't think of any websites, other than websites that have no traffic at all. If you have any reasonable amount of traffic, guess what? Some percentage of it's going to come from European Union member states, which in turn means that your EU data subjects are accessing your website. This means that all the software that you use has to be compliant with GDPR, like Google Analytics, for example, which sent out their notices yesterday. If you've done business with an EU citizen or an EU data subject, including non-financial transactions, GDPR applies to you the moment that citizen is on EU soil. So, for example, if you have download our free white paper, download our others, register for our free webinar, all those things, they're not financial transactions, but they are providing goods and services. And if an EU citizen or someone who is an EU data subject, who is within the physical borders of the EU, signs up for that webinar, guess what? Now all of your data collection has to comply with GDPR, even if you are based in Tasmania. GDPR applies to you because that traffic is coming from the protected area. Even if you're like a pizza shop in Nebraska, if an EU citizen gives you their personal information and then goes back to the EU, the moment they are on EU soil, if you use their data at all, or if they get back in contact with you, GDPR probably applies to you. Now, some of this is still a little bit murky because no enforcement penalties have started rolling out yet. That won't start until the 25th of May, 2018. However, don't risk it. And finally, for marketers, proving consent for our databases is probably going to be fairly difficult if we've done anything unclean. So buying a list, importing data, doing all sorts of stuff that we used to do all the time. Now, because of the way the law is structured, if there's any chance that an EU data subject is in our databases, that's a pretty good chance, we would need to essentially scrub those databases or re-opt them in to make sure that we are compliant. Now, some folks have said, well, I'll just pay the fines. No, you won't, unless you just want to go broke, and you don't like money. Why? The fines are massive. So per individual violation, you may be fined up to 4% of your annual revenue. So think about that. If you violate 100 people's rights, you could forfeit 400% of your annual revenue. The minimum fine is 20 million euros. So 20 million euros, relatively close to $20 million. Again, you violate 100 people's privacy, you're looking at $200 million in fines at a minimum. That's not something that most companies can afford to pay for. But the real teeth in this law is not the money. If you violate someone's privacy in a severe enough way, like a data breach that you fail to inform people on, for example, your company's executives can face criminal penalties, which is different than most other privacy laws on the planet. Company executives are not immune to prosecution. So it could get real interesting. So that sounds scary. What should you do? There's a long laundry list. Again, I have to re-emphasize, I am not a lawyer. I don't even play one on the internet. Talk to your lawyer. Talk to your legal team. Talk to your legal resources if you do business with anyone who is in the European Union. First, immediately review all your internal data governance, your policies, your practices, and make sure, put the GDPR legislation on one screen, put your policies and procedures on the other screen, and compare. Make sure that you are compliant. 2, check the terms of services for all your data processors and controllers. This means where you store your data and where you process your data. These are almost certainly companies. Google Analytics, for example, is a processor and controller. HubSpot is a processor and controller. Salesforce.com is a processor and controller. Whether or not you are doing business within the EU, these companies are pivoting and applying their procedures or creating new options that apply globally, which makes sense because this is an extraterritorial regulation. So you want to go in, you want to read carefully the notices that are coming out and then check which features apply to you. In Google's most recent email, they detailed, here are all the options now that allow you to become a GDPR compliant company, but the onus is on the company, you, to use the features appropriately to be compliant. Google is not enforcing compliance on everybody because they can't. It's just simply too large a logistical challenge. So you have to do the compliance checks yourself and make sure that you're using the features that have been rolled out in ways that are compatible with your business and compatible with the law. You need to update all of your public privacy policies to be compliant with GDPR. Remember, you have the right to be forgotten and the right to request data and the right to request data in machine-readable formats are now things that need to be in your privacy policies. So appoint somebody who's going to run stuff like that, some kind of project manager or coordinator, and then have a contact form on your website for GDPR compliance that says if you wish to invoke GDPR as an EU data subject, fill out this form and we'll do the thing. And that has to be in your privacy policies online as well. You must simplify your user agreements to compliance standards. So easy to read, easy to understand, no tricks, no gimmicks. When someone signs up for your service, you have to be as straightforward as possible about what's going to happen with their data and what control they have over it. And that's, again, part of the privacy policy. It has to be very, very simplified. Reduce the amount of data you collect to what is necessary for your business. So if your web forms are like this long, right, that's no good. Because every data point that you collect is a data point that you will potentially have to provide in either a right to be forgotten or a right to be known, or how you're known request. So if you're collecting 500,000 data points per person, you're going to need to store all that data, audit it for compliance, and then provide it on request and provide proof of deletion. So collect as little as you can while still being able to run your business effectively. Again, web forms, prominent privacy compliance notices, things like that. If your site uses cookies, guess what? They are collecting data. You've seen that on some sites saying, this site uses cookies. Well, look into the various, depending on what your content management system is, look into the various privacy plugin options to be able to display notices that are appropriate for your website that detail, here's what we're doing with your data. Finally, for those of you who are doing marketing analytics, data science, etc., part of that strengthened consent, the privacy by design, right to access and right to be forgotten, are understanding how consumer data is being used, which means that if we are using stuff in algorithms, we have to be able to explain algorithms and how they're being used. And so consumer data, if you're building black box AIs, not going to fly anymore. So you need to have and be using technology that has high interpretability so that you can explain how data is being used. One other thing that is important, I was talking with John Bowman, who is the head of Promontory, which is an IBM company that focuses on compliance. He was the UK's lead negotiator for GDPR. And one thing that's important on consent is that in addition to the simplification, consent also is per use case. So if I collect your email address, I have to state what I'll be using it for. I'm going to send you an email. But if I then want to use that email address for retargeting, guess what? I need to re-obtain consent for that use. So in the strength and consent section, people have a right to know how their data is being used, and we have to get explicit permission per use case. So again, if you want to use someone's data for machine learning, they have to consent to that, which means that we need to declare on the point of collection what we're going to be using the data for. And we need to obtain positive consent that someone says, yes, you may use my email address for email, for retargeting purposes, for advertising purposes, for machine learning purposes. All these things have to be detailed out in the simplified agreement as to what someone is consenting to. So that's a super important part. Now, this sounds like a lot, and it is a lot. It's a major change. That's why it's been a focus for major tech companies for the full 2 years since it was announced and approved. Last year, IBM threw this huge event in Germany for companies to get up to speed more quickly and to start using their software to get compliant with it. And so now we are about a month and a half away from the enforcement penalties taking effect, and now suddenly people are waking up going, oh, hey, it's just like Y2K, only we're completely unprepared. It's unclear how the compliance is going to go. Obviously, with 4% of your revenue per violation at risk, you don't want to just kind of poke your head in the sand. Do as much as you can. Read the law. Read the applicability of the law. There's an entire GDPR website, we'll put a link in the notes, that goes through the details of what's involved, and you then make your best efforts and you document the living daylights out of them so that if you do have to deal with the EU for a violation, you can at least show like you made your best efforts to be compliant with the law. That may or may not be enough, but it's better than just doing nothing. But if you're using third-party systems like from reputable companies like Google, like Salesforce, HubSpot, IBM, Microsoft, Amazon, those software packages and those services either are or are very close to full compliance. So as long as you're using the features and getting the features aligned with your use of your compliance with the law, you'll be fine. So that if you're using dodgy like bargain basement software, you may not be fine, and you may want to relook at that. So if you have any questions that I can answer that are not legal questions, happy to answer them. Please, for all legal questions, contact a qualified lawyer. Can't say that enough, can't say that loud enough. But compliance, especially for the small to mid-sized business, shouldn't be as difficult as it sounds. Again, just simplify those things and follow the laundry list. All this is in the blog post that goes with this video. Thanks for watching, and subscribe to the newsletter, subscribe to the YouTube channel, and we'll talk to you soon. Take care.